So with that in mind, the operative question then becomes whether you have a collateral order that follows from this immunity. And in that regard, the court's precedent is very helpful. Puerto Rico Aqueduct expressly says that it follows that you have a collateral order when an immunity from suit is at stake. Filarski and other cases have teased out the purposes, including Mitchell, for which immunities exist.
Why is the government on the other side from you then? I mean, that seems like a big...
It's a good question.
Big hurdle, and it's been that way.
Yes, well, it's been that way lately. So as I read the government's papers in this case, it is the reason that they're on that side is their legal conclusion about what's at stake. That is, whether it's an immunity or, as they have posited for the last 8 years, but not before that, whether it is a derivative privilege based on these sort of principal agency concepts. The government, to its credit, acknowledges that the impact on government operations from exposing its contractors to massive liability would be a significant obstacle. I think it's page 31 of their brief, and that Yearsley is critically important, page 3 of their brief. So I think we're aligned as to part of the point, but I'm aware of the seating chart, and I think the explanation is that they have this rather creative argument based on principal agent concepts, which in 1939 in Yearsley, they told the court that it was obvious as a matter of principle that contractors were immune. In Filarski, they said the same policy considerations apply. And then last week in Hinckley, it's page 10 of their amicus brief, they characterized Yearsley as barring suit. So I think it's a break from where they've been in the past, and as a result, Wythe versus Levine was the same situation where the government had changed positions. That's also wrong on the merits. I mean, it proves too much and too little, as we point out in the reply brief. Too much in that...
they say also that, I don't want to interrupt you there, but just so you can fold this in, they say there are other avenues for you for relief from this issue to be pursued.
Yes, and I can fold that in, because it proves too much in that employees who get qualified immunity and officers who have their own immunity, absolute immunity, also could avail themselves of 1292. And one of the odd things about the government's position in this brief is that it carves out a new and special rule unique to federal contractors that they have to go through 1292B. Nobody else has to do that involved in the process. So whereas in our case, you have GEO, for example, running a facility, and there are a number of ICE personnel. I think we have to provide 14 offices for ICE. There are 2 immigration courtrooms at this facility. Everybody involved, the ICE officials, the sovereign itself, are all immune and can all take a collateral order appeal. But the contractor, who is just doing what they're told, at least that's the presumption here under the second prong, is unable to appeal the denial of its immunity. So it creates a very odd loophole or gap in the operation of these programs.